This is magistrate court. This is the magistrate court sitting. Huh? As that is a judge's chair. You're comfortable.
Test, test.
Yes. Sorry, think it is what?
Test, test. So.
Which one?
Hello?
Think it's prosecution, Nevis defense, not the submission to be made by Nevis or Nevis team. And response from prosecution, think it's. She is a bit low.
Everyone. My name is Debbie, and on behalf of the Nevis Bar Association, and by extension, our law 2025 annual meeting, I wish to welcome you to our sixth form meeting competition. Thank you for attending today. We do trust that this event will be exciting and memorable to the students that are present. I would extend a warm welcome to my colleagues that are present today in person, as well as those of you that are attending via Zoom. Thank you. Do have fun, students, and I do trust that this experience and this event will be something that we can do.
Order, stand. Oyez, oyez, oyez. All persons who have anything before, any business before this magistrate court, district seat, Navy Circuit, join here and give your attendance by command of this honorable court. Lord save the king and this honorable court. Please.
Please call criminal matter any VMCR number 1 of 2020.
I'm Javid Edwards for the prosecution, and I'm joined by Mr. Kaydan Neal, Azaria Amrit, and Zariela Buchanan, all for the state.
Good afternoon. My name is Kikona Charles, and I am joined by my co-counsel, Kinayo Challenger, Alane Kati, Junice Eaton, and we are joined by instructing counsel, Angelique Prasad, Natalie Providence, and Talia Philip. Thank you.
Yes, we have heard the evidence that the prosecution has led, and now it is time for the defense to make any submission that they wish to make. I must indicate also that we have the Sinkits team for the prosecution and Nevis for the defense. So at this time, we're going to have Nevis team making a no-case submission.
May it please the court. My name is Kikona Charles, and I am joined by my co-counsel, Junice Eaton, Alan Nekati, and Kinayo Challenger. Also, we are joined by our instructing counsel, Angelique Prasad, Natalie Providence, and Talia Phillips. We appear on behalf of the defendants, Jack Richards and Ned Francis. Your Honor, the defense respectfully submits that there is no case for the defense to answer, and the charges ought to be properly withdrawn at this stage. Our submission is brought pursuant to the well-established principle in the King against Galbraith 1981, which directs that a case should not proceed where the evidence presented by the prosecution is either so weak or so inconsistent that no reasonable court, properly directed, could convict upon it. This afternoon, the defense will address two central issues arising from the prosecution case. First, Mr. Challenger will deal with the issue of whether the arrest of the defendants by police John Hank was unlawful, given the absence of a warrant, the lack of reasonable and probable cause, and the breach of the defendant's constitutional rights. Secondly, Ms. Carty will address whether the prosecution has proven the offense of larceny against the defendants beyond a reasonable doubt, as required under Section 3 of the Larceny Act. Lastly, Ms. Eaton will give a brief conclusion to wrap up the defense submission. Your Honor, before turning to those issues, I wish to note that the defense asserts that the prosecution has failed to establish any of the essential elements of the offense of larceny under Section 3A of the Larceny Act, which includes the following: the taking of property fraudulently and without a claim of right, with intent at the time of taking to permanently deprive the owner. Your Honor, we assert that the prosecution evidence is inconsistent and speculative. The alleged taking of the horse was based on assumption rather than observation. The element of fraudulent intent has not been proven, and the conduct of the investigating officer has tainted the fairness of the process. Therefore, there is no proof of taking and carrying away, no proof of fraudulent intent, and no intent to permanently deprive. Your Honor, with the court's permission, we therefore ask if we are able to proceed on the basis that this matter falls within the scope of the King against Galbraith, warranting a submission of no case to answer.
Yes, I will hear you on your point.
Thank you, Your Honor. Thank you, Your Honor. My colleagues will now develop these arguments in greater detail. May it please the court.
The first issue was the unlawful arrest. Your Honor, the cornerstone of this case lies not merely in what was alleged, but in how the law was disregarded. It is my respectful submission that the actions of Police Constable Hank were unlawful, unconstitutional, and against the very principle that safeguards every citizen in the Federation of St. Christopher and Nevis. The defendants, Jack Richards and Ned Francis, were subjected to an illegal arrest following an unlawful entry into their home, an act so unjustified that it offends both the rule of law and the Constitution itself. Now, let us begin with the facts. On the 5th of July, 2024, PC Hank, while on patrol, observed Lane Johnson chasing two men and shouting, "Thieves, stop." Those men, Jack and Ned, entered their home at Section 5 Pond Road and closed the door. Without hesitation, PC Hank, he broke that door down and arrested both men. He had no warrant, no consent, and no urgent reason. Officer Hank never told them why they were being arrested. And when he searched the house, he found nothing. Only hours later did the complainant claim to have found the alleged stolen hose outside, unsupervised and completely unconfirmed. No, Your Honor, our Constitution is not a suggestion. It is the supreme law of this land. Section 3 of the Constitution of St. Christopher and Nevis guarantees every person the right to liberty and security. Section 9 protects citizens against arbitrary search or entry. And most importantly, Section 5, subsection 2 states, and I quote, any person arrested must be told promptly the reason of their arrest. PC Hank's conduct violated each of these protections by breaking into their home without a warrant and failing to explain the grounds of the arrest. He acted not as a guardian of the law, but as a violator of it. In our jurisdiction, police powers are strictly limited by statute and by constitutional principle. A warrantless arrest is only lawful in limited circumstances outlined in Section 6(1) of the Police Act. Relevant to this case, where the officer reasonably suspected the person of having committed an offense. The case of O'Hara against Chief Constable of the RUC establishes how reasonable suspicion is proved. The alleged offense concerned a garden hose, an item of minor value, and hardly a matter threatening public safety. There was no violence, no immediate danger, and no evidence that the accused were attempting to destroy or take anything. A person's home is their castle and a private sanctuary that the police may not invade without legal authority. To do so violates not only the Constitution, but the common law principle that protects every citizen against arbitrary intrusion by the state. A warrantless entry into a home is never lawful. In this case, PC Hank acted nothing on more than the heat of the moment and a shout from a neighbor. The entry and the arrest were therefore unlawful, a clear abuse of power. This position has been upheld in courts around the world. In Lord Hanningfield versus Essex Police, the European Court of Human Rights ruled that police cannot lawfully enter a person's home without a warrant or consent, unless there are true emergencies, of course. That case made clear that a person's doorway is protected by law and cannot be crossed simply on suspicion. Similarly, in Keegan against the United Kingdom, it was held that an officer must announce both his authority and purpose before he enters a home, and failure to do so renders the arrest unlawful. Here, PC Hank did neither. He broke in without warning, without warrant, and without lawful cause. Even if, for the sake of the argument, PC Hank suspected theft, suspicion is not sufficient cause for immediate entry without a warrant. Proper procedure requires that he secure the premises, obtain judicial authority, and then execute a lawful search. His failure to do so renders both the arrest and the subsequent search invalid, and any evidence obtained as a result must be excluded. Turning to the Larceny Act, Section 3 defines stealing as taking property fraudulently without a claim of right, and with the intent at the time of taking to permanently deprive the owner. Yet, none of these elements can be proven here. The alleged items was never found inside the home. There was no possession, no concealment, and no intent to deprive. The arrest, therefore, lacked any foundation in law or in fact. Jack and Ned's own statements are consistent and credible. Jack explained that the hose lay across the fence dividing the 2 yards, and he simply lifted it up to coil it properly. Before he could speak, Mr. Johnson began shouting thieves and charged towards them. Frightened, the brothers ran indoors. Your Honor, hardly the conduct of criminals, but of 2 young men caught in sudden confusion and fear. Ned corroborates this account. The actions were innocent and certainly not deserving of the brutal treatment that followed. Your Honor, an unlawful arrest undermines the integrity of the entire prosecution. The Constitution cannot bend to suspicion. It demands due process, fairness, and the respect of the rule of law. When those principles are breached, the court must act decisively to restore them. The evidence gathered after such an unlawful act is tainted and cannot stand as proof in the rule of law. As held in the King against Galbraith, if the prosecution evidence is so weak, so inconsistent, or so incapable of supporting a conviction, the judge has a duty to stop the case. Here, not only is the evidence weak, it is based on suspicion. The prosecution case collapses as its foundation. Therefore, I respectfully submit that the arrest against Jack Richards and Ned Francis was unconstitutional and unlawful. The state has violated their rights under the Constitution and the principles of natural justice. Any evidence arising from that arrest is inadmissible, and the case against them cannot lawfully proceed. The only just outcome is a formal decision that there is no case to answer. May it please the court.
Thank you.
May it please the court. Your Honor, following on from my colleague's submissions, I rise to address the allegation of larceny. Your Honor, we say this is not a case of theft. It is a case of a misunderstanding of assumption replacing fact and of emotion outrunning reason. The evidence showed no dishonest intent, no possession of stolen property, and no proof beyond reasonable doubt that any offense of larceny was ever committed. Your Honor, the prosecution bears the burden of proof. It is their duty to show beyond reasonable doubt that these young men intentionally took what was not theirs. However, Your Honor, the facts tell a completely different story. Firstly, Jack and Ned were fixing the hose, not stealing it. Secondly, when Constable Hank entered their home, he found no hose at all. And thirdly, the hose was later discovered 2 hours afterwards outside the home, breaking any chain of connection to the 2 young men. When these facts are tested against established legal principles from the King against Thurborn and the King against Lyndon Oliver, the truth becomes clear. This is not a story of a crime. It is a story of a misunderstanding between the neighbors, which leads me to my first point. Your Honor, Jack and Ned were fixing the hose, not stealing it. Both defendants gave consistent statements explaining that the hose was lying partly over the low old fence between their yard and Mr. Johnson's. Jack picked it up to coil it back neatly on Mr. Johnson's side. Ned confirmed this. In the King against Lyndon Oliver, a person is guilty only if they act with a fraudulent intent to permanently deprive the owner of their property. Your Honor, there is no such intent here. No concealment, no removal, no attempt to sell or destroy the hose. Your Honor, even the complainants and neighbors' accounts reveal doubt. Lane Johnson admitted he merely saw them leaving his yard. Janice Brown admitted she thought they were borrowing something. Your Honor, we contend that suspicion cannot replace proof beyond reasonable doubt. DPP against Morgan teaches that if a person honestly believes they are acting lawfully, they lack the mens rea required for a crime. Your Honor, Jack and Ned honestly believed they were tidying up something that crossed the fence. Their conduct was open, their explanation consistent. What the prosecution calls theft was in truth an innocent act misread as wrongdoing, which leads me to my second point. Constable Hank searched the home and found nothing. Your Honor, even after the dramatic chase, the breaking down of the door, Constable Hank's own witness statement confirms that he searched the house and found nothing. Your Honor, there was no hose, no stolen property, nothing at all. In the King against Galbraith, where the prosecution's evidence taken at its highest is so weak that no reasonable tribunal could convict upon it, the judge should stop the case. The complete absence of physical evidence here makes conviction impossible. In Jerick against the state, the court held that possession of stolen property is vital to prove larceny. Without it, suspicion cannot fill the gap. Similarly, the state against Lashley 1999 reaffirmed that possession is the essential link between the accused and the act of theft. Your Honor, the officer did not witness a theft, did not recover stolen property, and arrested the young men solely because someone shouted thief. That is not evidence. That is assumption dressed as certainty. Which leads me to my third and final point. The hose was found 2 hours later outside the home. Your Honor, the alleged stolen item was not discovered until about 2 hours later outside near a banana tree. By then, Jack and Ned were already in custody. This time gap destroys any connection between them and the hose. In the state against Steer 1987, the court held that the link between an accused and an offense must be clear and unbroken. If the chain is broken, the case collapses. The hose was found in an open area accessible to anyone. Williams against the King confirms that without direct control or possession, larceny cannot be made out. Your Honor, even if the court accepts that Jack briefly handled the hose, handling alone is not theft. Your Honor, the delay, the location, and the lack of proof together reveals the same truth. There is reasonable doubt. And where there is doubt, the accused should not be called upon to answer the case against them. Your Honor, when these facts and principles are brought together, the prosecution's case falls apart. The defendant's explanation is honest and consistent. No stolen property was found in their possession. The alleged item was found later outside unconnected to them. The law from Galbraith to Lyndon Oliver, from Jerick to Lashley, demands proof. Proof of dishonest intent, proof of possession, proof beyond reasonable doubt. Your Honor, the prosecution has provided absolutely none. Accordingly, the prosecution has failed to establish the elements of the Accordingly, the prosecution has failed to establish the essential elements of the offense under the Larceny Act. May it please the courts.
Thank you.
Your Honor, having heard the detailed submissions of my colleagues on the unlawful arrest and the failure of the prosecution to establish the essential elements of the offense, I now rise to conclude the defense's submission. Your Honor, the prosecution has attempted to present a narrative of wrongdoing, but what has emerged instead is a series of assumptions, uncertain observations, and procedural breaches, none of which satisfy the legal threshold required to sustain a criminal charge. It is our respectful submission that the prosecution's case is so fundamentally flawed and that no reasonable tribunal could properly convict upon it. The prosecution has failed to satisfy even the minimum threshold required under Section 3 of the Larceny Act, as there is no credible evidence of aspiration, no proof of fraudulent intent, and no evidence of an intention to permanently deprive. The testimony linking the defendants to the alleged larceny is weak, inconsistent, and built on speculation rather than observation. As in the Queen against Shippey, 1988, the evidence is so unreliable that it cannot safely sustain a conviction. Furthermore, Your Honor, the conduct of PC Hank acting without a warrant, without reasonable cause, and in breach of the constitutional rights strikes against the core of procedural fairness. His actions taint the investigation and render any subsequent evidence unreliable. The principle in the State versus Galbraith is clear. Where the evidence is so tenuous, inconsistent, or unreliable that no reasonable tribunal could safely convict, the court must stop the case at this stage. This approach was reaffirmed in DPP against Varlak, which requires a judge to withdraw the case from consideration when the prosecution's evidence does not meet the minimum standard of sufficiency. Your Honor, the evidence before this court falls well below that standard. The contradictions, procedural breaches, and absence of proof create overwhelming reasonable doubt. A conviction in such circumstances would be unsafe, unjust, and contrary to the principles of fairness that guide this honorable court. Therefore, Your Honor, at the interest of justice, the defense respectfully requests that the court uphold the no case submission and dismiss all charges against the defendants, Jack and Ned. Unless we can be of any further assistance, these are our submissions. May it please the court.
Thank you very much. I will now hear the response from the prosecution. Yes.
Good afternoon, Your Honor. May it please the court. This afternoon, the prosecution will respond to the submission of no case to answer. The state appears through 4 counsel. I am Javid Edwards, appearing as Director of Public Prosecutions for the purpose of this exercise, and with me are my learned colleagues, Kaden Neal, Azaria Amrit, and Zariela Buchanan, who appear as supporting counsel. Our presentation will be structured in 3 parts, Your Honor. First, Mr. Neal will set out the relevant law that guides the court in assessing no case submission. He will identify the elements of the offense of larceny and the principles that determine when a submission of no case may apply. Azaria will then apply that law to the evidence before the court and demonstrate that each element of the offense has been supported by clear, consistent, and credible testimony. Finally, Ms. Buchanan will address the Galbraith test and explain why, based on the strength of the evidence, this is not a matter that should be withdrawn at this stage. Together, our submissions will show that the prosecution has met the required threshold and that this case must proceed. When they have completed their submissions, I will then provide a short overview and invite the court to find that the prosecution has met the threshold required at this stage. Respectfully, Your Honor, we say that there is a clear case to answer. May this please the court.
Good evening, Your Honor. My name is Kaden Neal. May it please the court, the defense has made a submission of no case to answer, pursuant to the principles in R. v. Galbraith in 1981. The prosecution respectfully submits that this is not a case where the court should withdraw the matter from the jury or, in this instance, from itself as trier of fact. The evidence before the court, if accepted, is capable of proving each element of the offense beyond a reasonable doubt. Accordingly, the submission should be dismissed and the matter allowed to proceed to defense. Now, Your Honor, the law states under Section 4 of the Larceny Act of St. Christopher and Nevis, larceny is committed where a person steals anything capable of being stolen, with intent to deprive the owner permanently of the same. The essential elements consist of 1. Taking and carrying away of property. 2. Without consent of the owner. 3. With intent to permanently deprive the owner. And 4. Property capable of being stolen. Now, Your Honor, as established in R. v. Galbraith, a no case submission succeeds only where 1. There is no evidence on which a reasonable tribunal could properly convict. Or two, the evidence is so weak or inconsistent that no reasonable tribunal could safely convict. If, however, the strength or weakness of the evidence depends on the view of witness credibility or reliability, the matter must be left to the trier of fact. I now allow my learned colleague to apply the law to this case. May it please the court.
Good day, Your Honor. Pleases the court. P.C. John Hank.
Could you start your presentation?
If it pleases Your Honor, I, Azaria Amrit, will be applying the law to the facts. 3 witnesses, Lane Johnson, Janice Brown, and P.C. John Hank, each provide consistent evidence that the accused were seen entering the complaint's yard, leaving with a green rubber hose, and fleeing upon being challenged. Lane Johnson evidence is direct and unequivocal. He saw both accused leaving his yard with his green garden hose. This is corroborated by Miss Brown, who saw the accused running back to their home with something green in their hand. This direct eyewitness testimony, supported by the late recovery of the stolen hose near the accused's house in their yard, clearly satisfies the actus reus of taking and carrying away. Your Honor, the defense indicated that the hose was not initially found inside the house, but that absence does not undermine the actus reus. Property may be discarded while fleeing, and in this case, the hose was later found on the accused's premises and identified by the complainant. Under Section 3C of the Larceny Act, for the purpose of this act, the expression carries away includes any removal of anything from the place which it occupies, but in the case of a thing attached, only if it has been completely detached. So, the hose was taken with intent to permanently deprive, and it was carried away in that it was removed from the complainant's yard. The court may therefore rely on the doctrine of recent possession, especially where no innocent explanation has been offered. Additionally, the item, a green rubber garden hose, is clearly property capable of being stolen. Lane Johnson identified as his with a distinct split near the nozzle repaired with his own tape. There is no dispute as to ownership or capability of being stolen. Your Honor, the defense have suggested a break in the chain of custody because the hose was found later in the accused's yard. However, the complainant identified his property promptly based on a unique tape repair. The short time lapse and the fact that the hose was found in the accused's yard maintains the integrity of identification and eliminates any real likelihood of mistake or interference. Additionally, Mr. Johnson expressly stated that he did not give permission to either accused to enter his yard or remove his property. The shout of "Thieves, stop!" is direct evidence that the act was against his consent. Your Honor, this also addresses any suggestion that prior neighborly interaction could imply permission. The complainant's immediate reaction, his pursuit, and his accusations all demonstrates a clear lack of consent at the material time. Moreover, intent is properly a matter for inference from conduct. The accused were seen running away upon being called out, refused to produce the hose when confronted by the police, and remained silent when asked about it. Further, the hose was later found hidden on their residence, not returned to the owner. These circumstances permit the court to infer a clear intent to permanently deprive. The explanation advanced by the accused within his witness statement that the hose merely fell over the fence raises a factual dispute, not evidentiary deficiency. Per Galbraith, such matters are for the trier of fact, not for determination at the no case stage. Your Honor, the absence of the hose within the house and the accused's silence does not weaken the prosecution's case. Instead, silence under questioning and the subsequent appearance of the hose on their premises fortify the inference of dishonesty. Any innocent handling of the hose, as claimed by the accused, is inconsistent with their flight, their locking themselves inside, and their refusal to explain themselves at the time. These matters are properly for your Honor's assessment at the close of the full case, not basis for withdrawing the matter now. Under Section 6, 1F of the Police Act, a police officer may, without a warrant, arrest a person in whose possession anything that may reasonably be suspected to be stolen property is found or may reasonably be suspected of having committed an offense with reference to that property. P.C. Hank observed the accused fleeing while being pursued by the complainant, shouting "Thief, stopped," an objectively reasonable basis for immediate arrest. His entry was justified under the doctrine of hot pursuit to prevent escape and secure evidence. The arrest was therefore lawful, and the admissibility of evidence remains unaffected. Your Honor, while the defense raises concern that the accused claimed that the officer did not initially state the grounds of arrest, this does not invalidate the arrest. The reason for the arrest was clear to the accused from the circumstances. The complainant was shouting "thief" as they fled. The officer joined the chase, and the confrontation occurred moments later. The common law doctrine of implied knowledge applies where the reason is obvious. Additionally, the officer stated that he did inform them that they were under arrest or on suspicion of larceny. Furthermore, although entry was made without a warrant, warrantless entry during continuous and immediate pursuit is lawful where necessary to prevent escape. The accused were actively fleeing into their home, slamming and locking the door behind them. The officer acted promptly and proportionately. This satisfies both the statutory authority under the Police Act and the common law principle of hot pursuit. May it please the court, my colleague, Ms. Buchanan, will examine the Galbraith test.
Thank you.
Good evening, Your Honor. May it please the court, I am Zariela Bakanan, appearing on behalf of the prosecution, applying the Galbraith test. Your Honor, applying the Galbraith test, the evidence in this case is not tenuous or inherently weak. It is direct, corroborated, and consistent. The only contradiction arises from the accuser's own statement, and that is purely a matter of credibility, which, following R and Galbraith, is for the tribunal of fact to assess. Where the prosecution's evidence depends on witness credibility or competing inferences, the case must proceed for evaluation at the close of the defense's case. Accordingly, there is clearly a prima facie case made out on each element of the offense. Your Honor, the prosecution has adduced, firstly, direct eyewitness evidence of the accused taking the property. Secondly, corroboration from an independent witness. Thirdly, recovery of the property in close proximity to the accused's residence. And fourthly, Your Honor, circumstantial evidence establishing both intent and possession. Taken at its highest, the evidence is capable of satisfying every element of the offense. The arrest was lawful, and there are no procedural defects fatal to the prosecution's case. Therefore, the prosecution respectfully submit that the defense's application for a no case to answer must fail, and this case properly proceed to the defense. Your Honor, my learned friend, the DPP, will now give a brief overview of our submissions. May it please the court.
Your Honor, my colleagues have already addressed the detailed law and evidence, so now I will give a brief overview of the prosecution's position. This case rests on clear and consistent eyewitness evidence. First, Mr. Johnson saw the defendants enter his yard and leave with his garden hose. A neighbor then independently saw them running back toward their home with a green object. A police officer then saw the complainant chasing them and joined the pursuit. Later that evening, the stolen hose was found near the defendant's house and identified by its distinct repair mark. Your Honor, nothing about this evidence is weak or unreliable. It directly supports each element of the offense and allows the court to draw the necessary inferences about intent. The arrest was also lawful, Your Honor, since the officer acted in fresh pursuit of a suspected offense. Under the case R.V. Galbraith, a no-case submission succeeds only where there is no evidence for the court to convict. Your Honor, it's the prosecution's position that this is not the case here. The prosecution has presented a strong and coherent case, and this matter should continue. Also, Your Honor, the defense mentioned that the defendants obtained and transported the hose merely to fix it or to repair it. If this is the case, why, when confronted by the complainant, did the defendants take evasive action and they also try to hide the complainant's property? Based on these evasive and untransparent actions, this honorable court can infer that there is clear motive and intent for the defendant's actions. Your Honor, for argument's sake, if the court were to take what the defense posited as fact, whether the defendant's taking away amounts to larceny is for the trier of fact, which is the jury, to determine. This further supports the prosecution's position that this case ought to proceed to trial. Your Honor, we therefore invite this honorable court to reject the no case submission. May this please the court. Thank you.
Yes. The defense argued that there is not sufficient evidence against the defendant, and so the case ought to be dismissed at this time. Yes, the prosecution responded to the no case submission as advanced by the defense counsel. Now, the defense counsel no case submission was that there was not sufficient evidence of the larceny. They also spoke of the unlawful arrest and anything arising from that arrest would be detrimental to the defendants. They also spoke about the Section 3 of the Constitution and also the prosecution or the police in this case, PC Hank, failing to tell the defendants why they were being arrested. Now, they said nothing was found on the defendants, and the defendants were merely wrapping up the hose that was in by the neighbor's fence. Now, the prosecution submitted that there is in fact a case to answer, and the prosecution relied on the statements given by the virtual complainant in this case, and also a Miss Brown and the police officer. Now, what is the evidence by the virtual complainant? And the evidence from the virtual complainant, Lane Johnson, is that he was coming home from work, and while on his way, he saw the two defendants in his property with his garden hose. And so he called out to them and they started running. Mr. Johnson is saying that he ran after them yelling, "Thief, thief, stop." And they ran into their house and closed the door. Now, the prosecution is also saying that the police breaking down the door and entering into the property was lawful. Now, I can tell you straight up, this is a case that will continue. The no case submission is overruled. And I say that because the issue of whether or not they could enter the property, the law provides in section 41 of the Larceny Act, it provides a person who is found committing any offense punishable under this act, except an offense under section 34, may be immediately apprehended without a warrant by any person and forthwith taken together with the property, if any, before a magistrate to be dealt with according to law. That section allows the police officer to arrest the person. Now, there was nothing found on the property. And so that in itself is of no moment in relation to the charge, because later that night, the hose was found next to the defendant's property. The evidence, to my mind, is sufficient for the case to proceed.
We're grateful, Your Honor. Thank you.
Thank you.
Much obliged.
Much obliged, Your Honor.
We shall take a moment to present tokens of appreciation to the young men and women that have participated in today's moot. We shall call your names one at a time, and you can come up and collect your token. So, Zariel Buchan. Kenayo Challenger. Alone Kati. Eunice Eaton. Natalie Providence. Angelinique Prasad. Talia Philip. Azaria Amrit. Ajanelle Brown. Jarvid Edwards. Our DPP. Dajeden Donrod. Kaidon Neal. And Kekona Charles. And last but not least, we have a token of appreciation to Her Honor, Magistrate Lasmin Clark. No, you were good. It's a close up. And lastly, we simply have a closing speech from or thanks from our president, Colin Merchant, who is present today.
Good afternoon. I guess we've been put on the spot. To the students, I think both teams did an And thank you for taking the time out to contribute to Law Week and preparing yourself and preparing so well for the moot competition. Well, we call it a competition, but I'm not sure if it's an actual competition, so I'll call it an exercise. Mooting exercise. I was also asked to give some general feedback. Delivery was good. I think the preparation always shows. The prosecution's team, I will give you a little extra congratulations, because I think that the quality of your presentation showed your preparation, your extra preparation. The speakers from both sides, you presented well. And I think Ms. Amaret in particular, you were quite well in terms of your delivery, your tone, the quality and substance of your speech was also well executed. The gentleman next to you, I must also commend you for your memory. I don't think I saw you glance at your paper once. That is impressive. I'd also like to congratulate the teachers who assisted the students and helped them to prepare. I don't know the full teams, but you know who you are. I think Azad and Mr. Liebert and Violet. So congratulations and thank you. Adrian and Sandra Hector, thank you very much. I would also like to express our appreciation to Ms. Clark. Thank you for taking the time out to assist us with this exercise. I know you always help when you can with Law Week, and we greatly appreciate the time and the efforts in this afternoon's exercise. Thank you, Phil Roy, as well, for accommodating us this afternoon. And, well, I don't want to say, well, before I get to the last, thank you for the attendees for showing up, supporting the students. We also have some persons on live on Zoom, and we stream the exercise on Facebook, on YouTube. So you can go back on the BAS YouTube page and look at yourselves. Share it with your parents, your friends, your family, and maybe in the next 5 to 10 years, when you are in a similar courtroom, or maybe this courtroom, you can look back at yourself and feel proud. And last but not least, Ms. Green, a special thank you. I don't think we've... Oh, my apologies. I forgot the prisoners. Thank you for your efforts and for participating in the exercise. And Ms. Green, thank you for your efforts. We have not had a moot, or I think a mock trial, for a few years. So I was happy to see the week of activities and this particular exercise has resumed and taken back its place in Law Week. So thank you very much to you and your team for your hard work, your dedication, and for ensuring that our future attorneys are taken care of during Law Week. Oh, and I'm told it's World Children's Day, so quite fitting. Just to put a plug in for the balance of the week, tomorrow we have a moonlight walk starting at the Mondo track at 6:15 p.m. We start at the Mondo track and we end at Sunshines. And then on Saturday, we have a catamaran cruise from Port Zante from 5 p.m. You can feel free to contact any members of the committee for any additional information. Thank you very much for attending this event and for your support during Law Week 2025. Safe travels over to the students and those who came over from St. Kitts, and have a good evening.